Good evening, class. This is Clinton Poteet, and this is going to be my video case brief. I'm going to be briefing Alfred Tompkins et al. Versus Annie Nannies Inc. et al. This is a Court of Appeals of Tennessee at Jackson's case. 59 Southwest, 3rd District, 669 be the page, year 2000. So we'll just jump into it. Alright, the facts are as follows. Plaintiff's 9-year-old child, Alexandria, while under direct supervision of her daycare center, broke both kneecaps while participating in a downhill race. Plaintiff sued the daycare center on a negligence theory, arguing that the daycare center breached their duty of care. The trial court directed a verdict for the daycare center, finding that the injuries sustained by the 9-year-old were not foreseeable, and thus no duty of care arose. Additionally, at trial, Plaintiff's counsel made an offer of proof whereby testimony was introduced that 2 girls fell and bumped heads in a race immediately preceding Alexandria's. The trial court excluded this testimony from the injury plaintiff's alleged error. And go a little further, as it says, on September 10th, 1996, 9-year-old Alexandria Tompkins, hereinafter Alexandria, was enrolled in the aftercare program at Annie's Nannies Inc. Annie's Nannies. Alexandria's aftercare teachers on that day were Teresia Simpson, Miss Simpson, and Clay Morgan, Mr. Morgan. Miss Simpson and Mr. Morgan took Alexandria and the other children to Cameron Brown Park. Upon arriving at the park, essentially, Miss Simpson and Mr. Morgan organized foot races for the children going downhill. Plaintiff's attorneys made an offer of proof at trial whereby Alexandria testified that she saw 2 girls fall and bump heads prior to her race. Alexandria, participating in the 9 and up race, ran down the hill. While running down the hill, she sustained injuries to both her kneecaps, where essentially their kneecaps broke. And that was determined on plaintiff's side that it was done because, or the kneecaps broke because of the race. The race itself was a huge contributor and essentially caused the medical necessity for Alexandria to go to the hospital because her kneecaps were broken due to the race. Again, the court excluded this testimony and found in favor of Annie's Nannies Inc. Now, when I say the court excluded that testimony, the trial court excluded that testimony. Not the Court of Appeals, the trial court at this point excluded that testimony. After the court made its decision and an order was entered regarding the matter at the trial court level, as you can see here, plaintiff's counsel timely filed a notice of appeal that would be determined by the statute for the appeal, and doing so alleged that there were 2 essential questions: whether or not the trial court erred in granting a direct verdict in favor of Annie's Nannies and its employees based upon its determination that defendants could not foresee injury to Alexandria, and whether the trial court erred in excluding testimony that 2 girls fell and bumped heads while running in a downhill race prior to the race in which Alexandria was injured, where Alexandria broke her kneecaps. So, as plaintiff is alleging that there is a negligence claim, negligence theory as it was earlier stated, there must be certain elements that must be proven. This would be the rule, the primary law, essentially, that must be proven in order for negligence to, for lack of better terms, be concrete and the negligence claim to be successful. And these are following essential factors of negligence: A duty of care existed that the defendant owed to the plaintiff. 2, the defendant's conduct fell below the applicable standard of care amounting to a breach of that duty. 3, an injury or loss resulted. 4, causation in fact existed. And 5, defendant's act or omission was the proximate or legal cause of the injury. And as you can see, it's pointed out right here. You can see Bradshaw versus Daniel, 854 Southwest 2nd District, 865, 869 Tennessee, 1993. That is another case that will substantiate the elements that must be proven in order for negligence to be allowed, more or less. Well, essentially, for negligence to further itself and be proven. Now we come down here, it says foreseeability is a test of negligence. Everyone has a duty to use reasonable care to refrain from conduct that will foreseeably cause injury to another. You know, you can see that in as it says here, see Doe versus Linder Construction Company, 845 Southwest 2nd Districts, 173, 178, Tennessee, 1992. Through a variety of case law that's stated here, it says, well, we'll cover a few of them, but it says, for one, specifically, the defendant, in order to be liable, must have been able to anticipate or reasonably foresee what usually will happen. Lancaster, versus Montesi. It follows logically then that scope of defendant's duty is based upon the foreseeability of the risk of harm involved. Basically saying, is it foreseeable that something could have happened, that kneecaps would have been broken because Alexandria saw two other children bump their heads prior to her having her race. They bumped their heads. Is it foreseeable that something could happen to Alexandria from that visualization? It goes on to further state that, again, there are two views regarding the extent of the defendant's duty based upon foreseeability. The first view, referred to as the limitation of liability to risk, is that no defendant is liable for consequences which no reasonable person would expect to follow from the defendant's conduct. It can be seen in, W. Page, Keaton et al., Prosser and Keaton on the law of torts. Further, it says, in Tennessee, liability is imposed upon a defendant when the injury caused could reasonably have been anticipated or foreseen. Then skipping down one line, you see the general rule in Tennessee is that negligence to be actionable must result in damage to the plaintiff, which the defendant could reasonably have anticipated or foreseen. Could it be reasonable to believe that an injury could occur to Alexandria based upon the visualization of what was just seen in the race prior to Alexandria's, where two other children bumped their heads in that foot race? In the instant case, coming down here, it says, in an instant case, two orthopedic surgeons testified that Alexandria's knee injuries occurred as a result of her running. It was reasonably foreseen that because the other two children prior to Alexandria's foot race hurt themselves, it could be reasonably foreseen that Alexandria, in some capacity, could hurt herself as well. Point of note is, neither doctor testified that her injuries were the result of falling. Although Annie's nannies owed Alexandria a duty of reasonable care, Annie's nannies could in no way foresee that Alexandria could be injured while running. It happened to where the individuals before Alexandria bumped their heads while running, but it could not have been determined based off that visualization, that perception, that Alexandria's kneecaps would be blown out, would be broken, snapped, however it was. And in this case, it was that Alexandria's kneecaps were broken during the race. Now, Annie's nannies may have been liable if a jury had determined such, if Alexandria's injuries were the result of a fall. The Tompkins place emphasis on the fact that Miss Simpson testified that if she had thought about it, she would have felt that it was unsafe to have the children run down the hill. Basically making the claim that it was negligent not to think on the basis of what could happen to children running down a hill. Not a flat surface, not uphill, but down a hill. That was a key point that the Thompsons placed emphasis on. You know, going two lines down, the standard is one of conduct rather than of consequences. It's not enough that everyone can see now that the risk was great if it was not apparent when the conduct occurred. You know, it has to be apparent, essentially, is what that was saying, but it is not enough that everyone can see how the risk was great if it was not apparent that the conduct occurred. So through the court's analysis, we essentially see that right here on review of this case, we've determined that the evidence in favor of the plaintiff, namely the testimony of Alexandria and the two orthopedic surgeons, suggests that Alexandria's injuries occurred while she was running. No evidence to the contrary was introduced at trial. Based upon this and the foregoing, we find that Alexandria's injuries were too remote to be reasonably foreseeable, and thus no duty of care arose. So, the Tennessee Court of Appeals affirmed the trial court's directing a verdict in favor of the defendant, Annie's nannies. As it says, we now turn to the issue that the trial court erred in excluding testimony regarding two girls falling and bumping heads while running in a downhill race prior to the race in which Alexandria was injured. Our review, the court's review, of a trial court's evidentiary rulings is whether the trial court abuses discretion. In Tennessee, admissibility of evidence is within the sound discretion of the trial judge. When arriving at a determination to admit or exclude even that evidence which is considered relevant, trial courts are generally accorded a wide degree of latitude and will only be overturned on appeal where there is a showing of abuse of discretion. And it was determined that there was no showing of abuse of discretion at the trial court level. And that was from Otis v. Cambridge, right here. Mutual, more than likely, Otis v. Cambridge Mutual Fire Insurance Company, 850 Southwest, 2nd District, 439, 442, Tennessee, 1992. Citations omitted. At trial, plaintiff's counsel made an offer of proof whereby Alexandria testified that she saw two girls fall and bump their heads. The trial court excluded the jury from hearing this testimony. Counsel for Tompkins argued on appeal that this testimony was relevant. More than likely, they would have said that it was pertinent, absolutely necessary, but relevant to show that Annie's nannies had notice or knowledge of danger. That the prior visual seen by Annie's nannies employees regarding the two girls bumping their head was sufficient to have the foreseeability that something could happen to Alexandria. Namely, what happened regarding her kneecaps breaking. So the Court of Appeals, Tennessee Court of Appeals, essentially say that falling and bumping heads is almost certain to occur when children run and play. Children are clumsy. It's not like an airplane. They're not aerodynamic. They're not a bird or a professional sports player of some sort. And even they get hurt as well. But falling and bumping heads is almost certain to occur. And this court fails to see how testimony of one is relevant to the determination of foreseeability of the other. Essentially, just because two children bumped their heads does not mean that it would be foreseeable that another child would have her kneecaps break in a downhill race. And the Tennessee Court of Appeals concludes stating, based on the foregoing, we affirm the trial court's granting of a directed verdict in favor of the defendant. And of course, costs, appeal, or tax to the Tompkins, as standard. So, as it can be seen through the totality of the circumstances, from the trial court making its ruling to the Tennessee Court of Appeals affirming the ruling of the trial court, that would be the conclusion and is the video case brief here at hand.